All right, again, welcome to oral argument session. I'm Judge Harris. Joining me on the panel today, Judge Eisnagel and Judge Wozniak. One case here at the 10 o'clock docket, Silver Springs Bottled Water Company versus Broadway. Each side has 20 minutes for their argument. Appellant, you can reserve as much you would like. On YouTube. That all being said, at this time, counsel for appellant, if you are ready, you may proceed.
May it please the court. Jessica Connor, on behalf of the defendant, Silver Springs Bottled Water Company, I'd like to reserve 5 minutes for rebuttal.
Okay.
Thank you, Your Honor. The Broadways filed suit in this case as a result of Mr. Broadway's fall on the defendant's property where Mr. Broadway injured his knee. After the jury rendered a defense verdict in this 7-day trial with 19 witnesses, the trial court granted plaintiff's motion for new trial on the grounds that 3 types of evidence should not have come into the trial. First, that evidence of Mr. Broadway's diabetes shouldn't have come into the trial. 2, evidence of his prior knee surgery shouldn't have come into the trial, and that testimony from the defendant's corporate representative, Keith Richmond, should not have been permitted because he was not specifically identified by name on the defendant's witness list, who we only identified him as the corporate representative. The trial court adopted the plaintiff's proposed order granting a new trial in all respects except one with regard to the jury instruction issue, which is the subject of the plaintiff's cross appeal. First, it was an abuse of discretion to grant a new trial on the grounds that diabetes should not have come into evidence because diabetes was in evidence because the plaintiffs put it there on direct examination of Mrs. Broadway.
So are you proceeding only on the argument that they opened the door? Are you abandoning your argument that it's not a collateral matter?
No.
Your first argument is it's not a collateral matter.
Correct, Your Honor. We are not abandoning that at all.
How is the diabetes not a collateral matter here?
It was not collateral because the plaintiff's CME expert included in his report that Mr. Broadway had diabetes as a part of his relevant medical history, which was pertinent to his life care plan.
And how did that affect the proposed life care plan?
The plaintiff's history, medical history, was clearly an issue that went to life expectancy.
Yeah, and but how did the diabetes specifically affect the life care plan?
Well, that was the thing. The plaintiff's expert later took it out of his report and said, oh,
counsel, in the report where it remained in the report, and what at the time that it was in the report, and you say therefore made it relevant, how was it relevant to the proposed plan? It decreased the life expectancy by how much?
There was not an opinion as to how long it decreased the.
So how was it relevant to the life plan then?
Well, we argue that it was relevant. Clearly, the medical history is there. The expert puts it there for a reason. That there's you have to figure out how.
But the expert. But
correct,
you don't know how. You don't know if the expert used it though, right?
That's correct, Your Honor.
Okay.
But it was also.
What other argument do you have that it was not collateral?
It was not collateral because it went to this expert's bias. He originally thought it was important enough to include it in his expert report. And then simply because the plaintiffs claimed that all of the medical records were in error, that it was a mistake that they said that he had diabetes. They said, Dr. Bafuco, all those medical records are wrong. It's a mistake. It shouldn't be in the report. And he removed it. This is a medical doctor removing from his life care plan what he found in the medical records to show that Mr. Broadway did in fact have diabetes. And despite all the medical record evidence to the contrary of what Mr. Broadway was claiming, this expert in blind reliance on what the plaintiffs were saying.
That's not the way I read the transcript, counsel, at all. I didn't read it as blind reliance. Now, maybe it was still an issue, right? But he explained, as I recall it, maybe unless I'm thinking of a different witness, he explained that once they told him that the diabetes reports were an error, that he went back and looked at the medical records and that it did in fact appear that the diabetes was an error based upon his review of the medical records. Am I thinking of a different witness?
Oh, he definitely said that based on his review, after Mr. Broadway denied having diabetes, that he then said, okay, well then I see in the records that I think this is an error, but
he corroborated it in the records. So that's not really a blind, I mean, you said blindly, and I don't think that's quite accurate, right? He claimed he corroborated it in the records.
Sure, he claimed he corroborated in the records, but the defense position was that this was not a reasonable position for a medical expert to take when the multiple medical records after records said Mr. Broadway has diabetes, he's treating for diabetes, he has prescriptions for diabetes, he had an A1C test on the date of the incident that showed his insulin, he needed to be on insulin on the date of the accident. And so the defense's argument was, despite that the expert had a reason that he came up with as to why he didn't believe the record showed diabetes, it was unreasonable because the records couldn't have been clearer, and we were entitled to an opportunity to show that that wasn't a reasonable position for this medical doctor to take, to just disregard these medical records that clearly said in black and white, Mr. Broadway has diabetes. There were records that said he's here today treating and follow up with regard to his diabetes, and he had prescriptions for them.
So if that's the reason for the relevance, why go into insulin and whether or not Mr. Broadway should have been on insulin, whether it was safe for him to drive a truck, all of the other issues that your client went into at trial? Well,
with regard to diabetes and insulin, the plaintiffs opened the door to that. So even concede.
No, counsel, hold on. That's the different issue, right? That's it. If it's collateral, then they open the door. We're still talking about, is it collateral? If the only relevance was, well, an expert opinion changed the report, why go into all those other issues related to diabetes?
Well, it turned out that whether he needed to be on insulin, it didn't on the day of the accident. It definitely turned out that all experts testified that insulin didn't have anything to do with causing the accident. And so diabetes was still, regardless, diabetes was still relevant to the issue of credibility because the plaintiffs opened the door to it on direct examination.
Okay, so you're really relying on the opening the door argument. I mean, it seems like
it's certainly our strongest argument, Your Honor.
Right. Okay, I mean, I tend to agree with you, but so why on that issue on opening the door, right? This isn't a situation where on direct examination, a witness just suddenly brings up an issue. Your client brought it up in opening statement. So why doesn't that make this a little bit different? And why, given that fact, why is the trial judge abusing discretion by concluding that the door was not opened?
Because what you have here is defense counsel made a statement, an opening statement about the bias of the expert in removing diabetes from his report. There was no objection to that. There was no motion in limine prohibiting defense counsel for making such a statement in opening. So it was not error to say this in opening.
Counsel, perhaps because everybody thought diabetes was irrelevant.
Well, I'm not sure how that could be, seeing how a motion to dismiss for fraud based on Mr. Broadway's lies and denials of having diabetes was filed pre-suit, and all the medical records showing he had diabetes were attached to that motion.
Nevertheless, once your client brings it up in opening statement, why? I mean, I guess if Mr. Broadway opened the door, why wasn't your client knocking on the door really hard during opening statement?
Because opening statement's not evidence, and the legal standard.
I understand that, but you expect a party to not respond to a statement made in opening statement?
They absolutely can respond, and that was their trial strategy that they decided to take. Instead of saying diabetes is irrelevant, objection, why are they even saying this in opening statement? And by the way, before I open the door to respond to opening statement, Your Honor, I'd like a ruling that diabetes is irrelevant.
So your argument isn't that they opened the door. Your argument is that they didn't object.
Oh,
different
it's
argument.
both. It's absolutely both. They
Well,
open
let's
the
go back to
door.
opening the door. Why, when your client raises an opening statement, why can't the trial court conclude, I don't think this is really opening the door when they address it in their testimony?
Because the law is, there is a standard for opening the door, and it's
Well, I
not.
understand that. Do you have a case? Do you have a case where one side raises the issue in opening statement, then the other side responds to that opening statement in their testimony, and a court concludes that's opening the door as a matter of law?
I do not have a case that's directly on point with regard to opening statement, but I do have cases, and it's the same cases cited by the plaintiff's attorney, that whether the door is open, considerations of fairness come in. So they absolutely had the right to take the strategic decision to respond to opening statement with contradictory evidence. But fairness dictates that the defense then gets an opportunity to cross-examine anything that came out on scope of direct. So within the scope of direct was a statement that Mrs. Broadway said, my husband does not have diabetes. It was entirely appropriate for then on cross-examination for the defense to get up and say, did I hear you correctly? Did you just testify that your husband doesn't have diabetes? That's right. He doesn't have diabetes. No objection. Then because she didn't, because she said, yeah, he doesn't have diabetes. That's when the impeachment started. Well, how about this medical record, Mrs. Broadway? Doesn't that say, nope, that's a mistake. What about this record and that record? 4 or 5 different medical records showing he has diabetes come into evidence without objection. It was waived. If they didn't open the door on direct, the error was waived on cross when they failed to timely object until way after the jury had already heard significant testimony about the medical records that clearly showed that they were not being truthful about this condition. So the case law is clear that once you fail to timely object, any subsequent testimony on the issue is harmless because it's merely cumulative to previously admitted, unobjected to testimony. And that's what you had here. And they conceded this point on appeal because there's zero argument in opposition to her.
This is the initial part, but then would you agree diabetes became a feature of the trial, right? Which is not usually a term we use in civil litigation necessarily, but I mean, a massive amount of the trial became about diabetes, right?
I would not say a massive amount because there were 19 witnesses. Only 4 of them testified about diabetes. 2 of those witnesses were the plaintiffs. The plaintiffs were the very first witnesses in this case to introduce the issue of diabetes, any evidence of diabetes. It was the plaintiffs.
And when the trial judge finally reined it in and said, okay, that's enough on the diabetes, don't go there anymore, and required your client to ask the question, hey, did this have any impact on the accident? And your client was required, your witness was required to say, no, it didn't. Then it seemed like that maybe sort of was the end of it, right? And that it had been mostly cleaned up and any prejudice had been dealt with. The trial judge made it very clear the position that the trial judge had at that point. But then your client continued to press on the issue of diabetes even after that, correct?
Are you referring to continue to press on it during Dr. Bain's testimony?
Yeah, by questioning, but both in not, I mean, certainly as I recall on Mr. Broadway's brothers, the cross-examination about Mr. Broadway's brother, right?
So the question was asked during Mr. Broadway's brother's testimony. There was an objection and there was no answer.
Right.
But with regard to Dr. Bain's testimony, you're correct. The judge repeatedly sustained the objection with regard to whether he needed to be on insulin on the date of the accident and any testimony about trying to tie it to the accident. Despite the fact that the objection was sustained, there was no motion for mistrial. And the case law is absolutely clear that it's an unpreserved error if an objection is sustained and you don't then move for a mistrial, or you say, look, Your Honor, Dr. Bain, the defense own expert, just conceded that diabetes had nothing to do with the fall, but I still think the jury is confused about this issue.
Why is the trial judge?
They didn't do that.
Why is the trial judge abusing their great discretion in this case, right? I mean, the standard of review is significant here, right? Why is the trial judge abusing discretion when, you know, counsel maybe lets it go for a while, but eventually says, no, this is irrelevant. The trial judge says, yes, you're right. This is going to end. And then your client continues to pursue it. Why does counsel have to object from the very beginning? Why at some point the objection is lodged, the trial judge agrees, the trial judge says enough's enough, and then your client continues down that avenue nevertheless, despite the trial judge's instruction. At some point, why doesn't it become something that a trial judge can grant a new trial on without abusing discretion?
There's two specific issues that we have to separate. One, whether or not Mr. Broadway's had diabetes. Two, whether or not he needed to be on insulin on the day of the incident. With regard to whether or not he had diabetes, any error with regard to that specific issue was fully waived. Even during Dr. Bain's testimony, plaintiff's counsel expressly waived any error and said, look, Your Honor, I'm fine with him testifying about what he saw in the records that Mr. Broadway had diabetes. But Your Honor, I am continuing to object to the issue, any inference that diabetes caused the fall. So the first issue was already conceded and waived. With regard to tying it to the fall, that was clearly sustained, and there was no motion for mistrial. And the Florida Supreme Court in Campagnoni versus City of Tampa.
Counsel, there was a motion for mistrial, just maybe not when you think it should have been.
It was untimely, and in the answer brief, they do not raise that at all. This is the thing. They have conceded that when the objection was sustained, a motion for mistrial should have been made, but their argument is that there was no sustained objection. The argument in the answer brief is that the objection was overruled. The trial transcript does not lie. It's on page 740 of the trial transcript. Question about the insulin, needing to be on insulin on the date of the incident. Objection, Your Honor, followed by sustained. And so they argue that the objection was overruled. It wasn't overruled. And they don't, but so they concede that because it was sustained, according to the Florida Supreme Court, when an objection to attorney misconduct is sustained, quote, the party must also timely move for a mistrial in order to preserve the issue for a trial court's review of a motion for new trial. So it's a clear abuse of discretion.
Ms. Connor, I don't want to interrupt you or cut you off, but you are about a minute and a half into your rebuttal time, just so you're aware.
I would like to just ask one question. I apologize. I have some laryngitis today, but I want to be clear. So the standard for preservation to get a new trial, is that the same as the standard for what's required for preservation to raise an issue on appeal?
It is the exact same standard, Your Honor. It has to be preserved for post-trial review on a motion for new trial in the exact same way that it's preserved on appeal. And that requires a timely motion for mistrial after a sustained objection. There was no motion for mistrial, and I will reserve the remainder of my time for rebuttal.
All right, thank you, Ms. Connor. And the time that you do have left, I would like to discuss as much as you can the prior knee surgery issue as well.
Yes, Your Honor.
Okay, Mr. Walsh.
Good morning, Your Honors. My name is Peter Walsh, and I represent Tony Broadway and Gianna Luisa Broadway. Because we've filed a cross appeal, I'd like to reserve 5 minutes for rebuttal.
That's fine.
Your Honors, the new trial order sets forth 7 separate and independent grounds for a new trial. Because the new trial order is supported by these 7 separate and independent grounds, Silver Spring's burden here is formidable. I would argue it's simply insurmountable. That's because Silver Spring must prove that our trial judge abused his discretion on all 7.
And the counsel, I think the problem for you, I mean, I think you have a decent argument on the diabetes issue that it was a collateral issue, but you know, reading the transcript, your client allowed a substantial amount of testimony on this issue before even raising the first objection, and indeed is the first one to offer evidence in testimony. I mean, I understand that the other side raised it in opening statement, but how did you not open the door?
Well, we didn't. In order to open the door, you have to be the person who introduces it. But I would argue that our failure to object at the very first mention of diabetes, we didn't waive anything. I mean, trial counsel.
No, I'm asking you about opening the door during the direct examination of, I believe it was Mrs. Broadway, right?
That's right. That's right.
Right.
And Judge Eisnagel, I agree that what defense counsel says in opening is not evident. That's indisputable. Nevertheless, there is nothing that prevents a judge from allowing a lawyer in direct to address something that his or her opponent made in opening.
I mean, that's true, but counsel says, look, I mean, yes, you had every right to address it, but once you do that, I mean, isn't the cat out of the bag? You've sort of opened up the issue to now debate, right?
No, respectfully, Your Honor, the cat was out of the bag in opening. I mean, they made a statement in opening that had to be addressed on direct.
Well, no, it didn't. You could have objected.
Well, we did. Well, but what would have happened if I had objected? Remember, we did object in opening to one thing that counsel said in opening, and the judge properly overruled the objection. Why? Because the judge hasn't heard the evidence yet. The judge is not in a position to know whether it's going to be relevant or not. If we had objected in opening to what they said about diabetes, the judge would have done just what he did in our previous objection, which is overrule the objection, because the evidence, defense counsel would have said, well, the evidence is going to show this.
Well,
So-
wouldn't your argument that you didn't open the door? Sorry, go ahead.
There was no motion in limine filed as to diabetes at all, correct, pre-trial?
That's right, Judge Wozniak. In fact, we had I can tell you, we had no clue that diabetes would have been raised as an issue in this case. Remember,
How could you have no clue when there was the motion to dismiss based on fraud? If I was an advocate and I got a motion like that on my desk, it would definitely ring a bell to me.
well, because number one, if the defense is going to have their expert testify, their medical expert testify that indeed this fellow had diabetes, that's something that would have been disclosed in their expert witness disclosure. Their failure to do that led us to believe that it wasn't going to be an issue, that it was an issue only in their motion to dismiss for fraud. And in the motion to dismiss for fraud, what they really argued was the knee issue, not the diabetes issue. Judge Wozniak, you're absolutely right, though. They did throw the diabetes issue into the motion. But diabetes, remember, diabetes, we know, had absolutely zero probative value in this case. We know that because the defense's own expert, Silver Spring's own expert, told us that. So why would counsel think that defense counsel is going to violate the rules and introduce a completely irrelevant topic, namely diabetes, just for the purpose of—
Well, counsel, as far as opening the door, wouldn't your argument be stronger? And this doesn't necessarily mean you lose, but wouldn't your argument be stronger had you objected during opening statement, had the trial judge overruled your objection, and then you're sort of in the position where, well, now we tried to object, but now we have to respond, and perhaps even a better practice would have been to wait for the other side to actually raise it in testimony before you then address it in your own testimony. Then there would be no question that you didn't open the door, right?
Well, yes, certainly. I would be I'd have a stronger argument if indeed I had objected in opening. But again, a trial, if trial lawyers objected to everything in opening that they believe the evidence will not show, then opening statements would be bogged down with literally 30 objections. Okay, at least it doesn't.
So that's a fair point. But the other thing you could have done, though, right, is let it go in opening and then not touched it during your direct examination. Wait for the other side to raise it, whether that be on cross or in their own witnesses. And then at that point you object, right? And if the objection's overruled, now you're safe. Now you're safe to address it without opening the door.
Opening the door is a judgment call that's made by the trial judge at the scene. I don't think Judge Scott abused his discretion by finding that our limited, and it was a very narrow, limited addressing of the issue that we did on direct. The judge did not abuse his discretion in finding that we did not open the door. I think that's really a call that that he's in a position to make, and I think the case law supports that he's got
Counsel,
discretion.
on that point, I've seen a lot of appellate cases that affirm a trial court on the issue of opening the door. I don't know that I remember seeing one where an appellate court has reversed a trial court on opening the door, on an opening the door issue. And perhaps that's because trial judges are entitled to deference on that determination. But are you aware of any appellate case in Florida reversing the trial court when the trial court finds the door was not opened?
I have not, Your Honor, but I can't conclusively say that there is no such case, but I certainly would be duty bound to bring it to the court's attention if there were such a case, but I don't know of one.
Okay.
So
Mr. Walsh, about the testimony on diabetes, aren't there references to diabetes throughout the medical records?
There are, well, not many, Your Honor. In the thousands of pages of medical records, there were far more records that failed to mention diabetes as an underlying condition.
But diabetes is maybe not replete, but it's mentioned throughout the medical records, which the parties stipulated would come into evidence. There was no motion to redact that portion at all. So the information of diabetes was going to be in front of the jury anyway, regardless of whether it was elicited through direct testimony, right?
That's right, Your Honor. But by stipulating to the admissibility of that evidence, we weren't stipulating to the accuracy and relevance of everything in the records. For example, if there had been a reference in there that Tony Broadway suffered from cancer, and that was an error, well, I mean, the defense couldn't have come in and said, well, he's lying about cancer. That's a collateral matter. But so I think although there are references, those references are scattered. And the way this would have been dealt with is by having Tony Broadway testify, as he did, and as Jenna Luisa testified, that this was a simple mistake. The problem is, what made this into the linchpin for the defense was having their experts seal the deal by testifying that, in fact, Tony did have diabetes, therefore proving that Tony lied. That was the linchpin. This evidence would have been much less harmful if that expert didn't give that damning testimony that Tony Broadway, beyond doubt, suffered from diabetes. Up until that point, we could argue it's just a mistake in the records. But when he testified to this undisclosed opinion, suddenly the jury is left with only one conclusion. This guy's lying. He's covering up. And by the way, he's probably a reckless, crazy driver. He shouldn't have even been driving that truck that day. So it's doubly prejudicial. And I just would ask the court to keep, top of mind that there are 7 independent grounds to affirm the trial court, and this court has to affirm the trial court, unless it finds that the trial court abused its discretion on all 7 of these areas: the knees, the diabetes, the 403 balancing as to the knees.
How is the knee collateral? I mean, it seems to me that their theory at trial was, look, your client didn't slip. Mr. Broadway didn't slip. He jumped off the truck. And I think they even argued this in closing, that he jumped off the truck, had a pre-existing knee problem. The force from that jump off the truck causes knee to buckle. And that's why, by the way, also some of the statements that he made are inconsistent about how the accident happened. Wasn't that their theory? So how would a prior knee surgery be collateral given the actual arguments that they made and also the evidence of conflicting statements about how the injury happened?
Well, I don't think, with all due respect, that there were conflicting statements about how the injury happened. Defense counsel certainly suggested by trying to impeach.
Well, there was one witness that said, well, Mr. Broadway told me that it happened while getting off the truck or something like that. Right?
Right. You're right. And one of the doctors, who's, by the way, is not a native English speaker, testified in deposition. I think he said he fell while getting off the truck, but he also, sort of wavered on that testimony. He finally said, I don't quite remember exactly what.
But counsel, I think that's kind of all aside. Those are all factual questions for the jury. My question to you is, why doesn't the other side's theory of the case, theory of the injury, how the injury happened, why doesn't that make prior knee surgery a relevant issue?
Prior knee surgery becomes a relevant issue only if there's medical expert testimony making it a relevant issue. For example, they can't just say, well,
it has to be an expert.
excuse me, Your Honor.
Sorry. What case says that it has to be an expert to bring it in?
Well, I mean, I don't have a specific case, but I can tell you there is a plethora of case law that says that juries can't be left to speculate about the influence of a medical condition on causation of an accident. I mean, just, you know, the evidence was overwhelming that there was no prior knee surgery. What the defense, Silver Springs, came up with.
Counsel, assume for a minute there was a prior surgery. I think what you're trying to say, and I think there may be some merit to this argument, perhaps. What you're saying is, look, just because there's a knee surgery doesn't mean that Mr. Broadway's knee was more susceptible to this type of injury without some expert coming in and saying, yeah, I mean, this type of knee injury that he had surgery for is going to weaken the knee in this way and increase the likelihood of this injury, right? Is that what you're saying?
Exactly. Thank you, Your Honor. You articulated.
And you're saying there wasn't any such testimony to tie it together.
That's right. So, and we don't know whether this prior knee surgery, and again, Your Honor wanted me to assume there was. We don't know whether this prior knee surgery was a pinprick sort of arthroscopic surgery where that was an in and out patient procedure that took 2 seconds that left the knee not weaker but stronger, or whether it was a total knee replacement on the other end of the spectrum. And without that testimony, the fact that someone had prior knee surgery has absolutely no relevance whatsoever to causation.
You're saying the jury can't assume that every single knee surgery on the planet is going to increase the risk of this type of injury.
Exactly.
Okay.
So, you know, again, if this court finds that even any one of the 7 grounds that the trial court came up with for justifying a new trial, even if Silver Springs fails to prove that even one of those 7 options was an abuse of discretion, then this court has to affirm. And to take what I think is sort of the most direct route to an affirmance, I think if this court looks at the issue of expert witness disclosure, expert witness testimony, I think that's the cleanest, well, I mean, I think that's the most direct route to a proper decision, which is an affirmance, because this court has held in the Cascanet case that we cited, Cascanet v. Allen, the 2011 case, that undisclosed expert testimony that violates the pretrial order, rules of civil procedure, and is just trial by ambush is sufficient to justify the grant of a new trial. And so if this court looks at the fact, and it's undisputed, that Dr. Boehm never disclosed to anybody that he was planning on testifying that Tony Broadway did not have diabetes, well, then that right there is within the trial judge's discretion to grant a new trial for that ground alone. So unless Silver Springs can tell the court that that's an abuse of discretion and prove it to this court, well, then the court is obliged to affirm. And remember, if we had known that Dr. Boehm was going to testify that Tony Broadway had diabetes, well, we would have been prepared to call one of Tony's treating doctors to explain the reference to diabetes in a record. We would have been able to file a Daubert motion to challenge Dr. Boehm's testimony.
Counsel, you did explain the reference to diabetes, right? I mean, you ended up explaining it. I mean, one of your witnesses said, look, a mistake in a medical record often gets carried over, just gets automatically copied over to other medical records. It happens. And so how did you not have the explanation sort of, I mean, I get what you're saying, but I guess the counter argument is, well, look, at the end of the day, what's the prejudice? You were able to offer the explanation, right?
Yes, but my offering an explanation was such a weak response to decisive medical expert testimony. I mean, I can't battle an expert with a non-expert.
Well, I think your expert who testified as such even said, look, I'm not really qualified in this area. I don't do this type of medication, but this is what I happen to know generally, right?
That's right, but he was not an IME doctor. He was a life care planner. So we would have mounted a much more robust defense if we had gotten the notice that the rules say we must get, that Dr. Boehm is going to offer this testimony at trial. We didn't get that notice, and as the case law says, we can't defend.
Judge Harris, you're muted.
Thank you. Mr. Walsh, you are into your rebuttal time, just so you're aware, and you've not addressed any issues from your cross appeal. So I don't know if you want to do that now.
Well, yes, Your Honor. The cross appeal is a very simple, straightforward issue. We submit that under the standard jury instruction, we do not have to enter the statute into evidence in order to argue that violation of that statute constitutes evidence of negligence. The jury instruction does not require the entering of the statute into evidence. In fact, it provides an alternative for the judge to read the instruction to the jury without any reference to it having been entered into evidence, or the judge can summarize the statute to the jury. And we had testimony from our expert that statute was violated. At least one statute was violated. So we think the jury instruction itself does not require us to submit it into evidence. And we think that's grounds for reversal if, and again, the court doesn't even reach that issue, unless it finds that the trial court abused its discretion, not once or twice, but 7 times on all 7 of the alternative grounds. And remember, the final ground the judge offered was the ground of cumulative error, that even if one of these errors did not justify a new trial, cumulatively, at least 2 or more of them did.
I have one more question on the preservation of error issue. And I'd
Yes,
like
Ron.
the opposing counsel to address this too on rebuttal. If we were to find that plaintiffs did not preserve the issue of the diabetes being a collateral issue, for example, does the trial court still have any discretion to grant a new trial? Or would you agree that that would be an abuse of discretion if there was no preservation and that's an issue?
I think, Your Honor, that the trial court does enjoy broad discretion to find that we raised it at the right time. Remember, the trial court is there on the scene, on the ground, seeing the ebb and flow of the evidence. And the trial judge is in the best position to decide, in all fairness, whether we raised the objection soon enough. I agree, the objection wasn't raised. Evidence of diabetes there was questions about diabetes maybe 2 or 3 times before the 4th time when an objection was made. But by the way, what happened when that objection was made? When we raised it the 4th time, the judge overruled the objection. Well, the judge, because the defense promised the court that they were going to tie it together. And then when it came time to tie it together, their own expert had to admit that they can't tie it together.
So your argument is that if we find that you failed to preserve, let's say, the diabetes issue, that the trial court still has discretion to grant a new trial on that issue?
On that issue, I do, Your Honor. I think it's within the trial judge's discretion for the reasons I just stated.
All right, any further questions from the panel? Okay, thank you, Mr. Walsh.
Thank you, Your Honor.
Ms. Connor, you've got about 2.5 minutes.
Yes, Your Honor. I have to very quickly correct something that counsel repeatedly said about the cross appeal issue, the jury instruction. He kept referring to a statute that they didn't need to move into evidence. That it wasn't a statute, and that makes a big difference. They were trying to get a jury instruction based on an ordinance or a building code, which is not a statute.
Did you need expert testimony to make the knee surgery relevant here?
No, there's absolutely no case that says you have to have an expert. What we had instead was testimony from Mr. Broadway himself saying originally that the reason why he fell was because his knee gave out on him, it buckled, and then he fell. But we did have expert testimony. The plaintiff's own expert said that prior knee surgery was not just relevant, but highly relevant. Dr. Bafuco, plaintiff's expert, says, as a physician writing a life care plan, if someone had had an injury to that same knee, which maybe made him more predisposed.
So he was looking at the life care plan, not at the cause of the injury, right?
I'm sorry, Your Honor.
he was looking at, he was doing the life care plan. He wasn't opining about the cause of the injury necessarily, was he?
Yes, he said if that would make him more predisposed to this injury on that date, I'd want to know that was something that was highly relevant
So
to
testimony was enough to establish every knee surgery under the sun makes a knee more predisposed for this kind of injury.
Every knee surgery under the sun doesn't make him more predisposed to this. But what's important is the case law is crystal clear. You don't have to have the exact same type of prior injury. Quote from the 4th District in JVN Enterprises versus Prentice, while the prior injuries may not have been the identical injuries sustained in the subject case, they involved the same general area of the plaintiff's body and were relevant to the plaintiff's credibility in light of his lack of memory.
But you're saying any knee injury, any knee surgery, regardless of what type of surgery it is, what part of the knee, how invasive it is going to be increase the risk of this type of injury. That's what you're saying?
I'm not saying that any type of prior knee surgery is going to necessarily increase the injury. I am saying that because the knee is the material issue in this case, that anything regarding the knee is material, and if he lies about it, it goes to credibility, and the case law is clear. It doesn't have to be the exact same injury. If it only pertains to the general area of the body, and here it's not the general area, it is the area, it's the knee. Because it pertains to the knee, it's relevant to credibility. If this man's gonna lie about what he thinks is harmful to him because it has to do with the knee and issue in this case, the jury gets to know that. If he's going to lie and say he never had prior knee surgery, those records showing prior knee surgery in his own handwriting or his wife's handwriting comes in. Otherwise, this is a charade. It's a charade. And if this case gets retried, what's going to happen is we're going to go to trial. Mr. Broadway's going to get on the stand and he's going to deny a prior knee surgery. And the jury will never, ever get to hear that that's a bald-faced lie in 2 medical records from 2 doctors in 2 different states separated by a year in time.
All right, thank you, Ms. Connor. That is your time. Mr. Walsh, we can give you just a few seconds to respond if you'd like.
Well, Your Honor, I think my response is limited to the jury instruction issue.
Yes, sir, it is.
So my response to that is the jury instruction does not distinguish between a statute or an ordinance or code violation. It lumps them together. And there's no principled reason for the rule to suggest that if it's a statute, it has to be introduced into evidence. Excuse me. If it's a statute, it doesn't have to be introduced into evidence. But if it's a code or ordinance, it does. There's no such difference. If you read the rule, there's no such difference.
Thank you, counsel. Thank you both very much for your presentation in this case. Court's going to stand in recess at this time. Have a good day.
Thank you, Your Honor.
Thank you, Your Honor.